नहीं एंटरटेन करेंगे, जिसको देना यहाँ पे छोड़ दो या ड्रॉप बॉक्स में डालो, दैट्स ऑल। Yes, madam.
With my lord's permission, my lord, this is the Supreme Court's piece for last year. This is the Supreme Court's judgment. In totality, it's important, my lord. Why? Because the matter has been totally dealt with. I've also flagged it, my lord, because it becomes very important.
Madam, confined to your arguments to the delay only.
Because yesterday they went on the merit basis regarding payment.
No, this is first delay matter, then we will condone the delay, then fix the appeal for final.
Insofar as the
No, what do you want?
Beg your pardon?
Delay should be condoned first, then the appeal.
But he did not.
So then that confined your argument to delay, that's all.
Obliged to my lord.
Yes.
But insofar as the delay that we have put across in our reply is 1631 days from the date of the knowledge, that is 13th of July 2020, when the Tehsildar passed the order, my lord, regarding the objections, my lord. So they were aware of it, my lord, from 13/7/2020, my lord.
Right.
And how do I say this, my lord? Yesterday I would be wasting my lord's precious time.
Delay application.
R11, my lord.
Delay application.
R1
Yes.
along with my reply, please. Am I there with my lords?
Their reply.
This is order of 13/7/2020, my lords, which is of the Tehsildar.
Sorry, which para you are referring?
I'm
Which
to
which
R11.
which para to your reply you are
I
aware?
reply,
Yes.
which is dated 17th of March 2025.
Yes.
Am I there with my lords, please?
Yes, please.
Now, this is, I'm taking my lords to R11, my lords, is an order which came to be passed by the Tehsildar, Nuzul, Belberagar, Bhopal. Now, this is of 13/7/20, and who are the parties herein? BM is the applicant, my lords, and everybody. Then we have Amkeshwar Anand, we have Menaka Gandhi, and we have Ambika Shukla, who are before this court as an appellants, my lords.
Right.
Now, when they are before the Tehsildar, the order is passed on 13/7/2020. Why? Because they submitted their objections. So they were aware of so many things, my lord, at that point of time. And how do I say that, my lords? Let's have a perusal at para number. I'll take my lords to the internal page 5 of the said order to see that they had the knowledge. I'm at para number 2 at that page, my lord.
Yes,
Am I
please.
there with my lords, please?
Yes, please.
Now, Vedak Virendra Mohan Singh, that is the respondent hearing, my lords, के द्वारा माननीय उच्च न्यायालय जबलपुर में MCC नंबर 820 एवं WP क्रमांक 52720 जिसमें माननीय उच्च न्यायालय के द्वारा दिनांक 3/3/20 को आदेशित पारित करते हुए निर्देशित किया गया कि तहसीलदार जिला भोपाल आवेदन दिनांक 14/10/20 के संबंध में 4 सप्ताह में बोलता हुआ आदेश पारित करे, परंतु कलेक्टर महोदय जिला भोपाल के आदेश दिनांक 21/3/20 से कोरोना लॉकडाउन के कारण न्यायालय बंद थे, परंतु कलेक्टर महोदय जिला भोपाल के आदेश भोपाल दिनांक 3/7/20 से पुनः न्यायालय आरंभ किए गए। माननीय उच्च न्यायालय मध्य प्रदेश जबलपुर के आदेश 3/3/20 के पालन में प्रकरण में आज दिनांक का आदेश पारित किया जा रहा है। तो जब आप पार्टी हैं तो इस बात का आपको नॉलेज है कि ये सब प्रकरण चले हैं। Now, the next for my lord's appreciation would be, my lord, that when my lord we filed a petition or आदेश हुआ था my lord 3/3 का, that was an order, first order which was passed in the WP number which we had filed was 5227 of 2020. जो पहला आदेश हुआ वो था 3/3/20. The order of course was little vague, but we went before the Tehsildar to look into it. But Tehsildar ने compliance नहीं किया. So we filed a contempt petition 428 of 2021. Learned single judge on hearing us was kind enough to issue notice to the Tehsildar. Tehsildar थे, गुनीता को पार्टी नहीं थी, Tehsildar, because he was not complying with the High Court's order. So 11/5/2022 के आदेश में थोड़ा सा punitive भी बोल दिया था कि why you should not be punished. So against that order of 11/5/2022 when it was pending before the single judge, Tehsildar did not go to any court of law. It was Gunita Kaur who goes in a writ appeal before this honorable court which is writ appeal 664 of 2022, my lords. Now, when the matter is pending here, Menaka Gandhi and Ambika Shukla traveled to Supreme Court on the same order of 11/5.
Yes, yesterday we argued that there.
हमने बोला था
Yes.
तो सुप्रीम कोर्ट ने ये कहा आप जाइए, मामला जब कोर्ट में लंबित है तो आप अपने आप को इम्प्लीड कर दीजिए और वो डिस्पोज ऑफ हो गया.
Right.
That is on record, my lords. Now, this appeal was finally allowed, and then we sought a liberty because there was some sort of a cryptic order, grant us a liberty for preferring a review. The division bench of this court in the said writ appeal granted us the liberty, my lords, to prefer a review. Accordingly, we filed a review 242 of 2024, and that order was passed, my lord, on 23/4/2024, wherein the learned single judge, it has to be in accordance with law, meaning the decree was passed by the Supreme Court. So it was intended that the order has to be passed, whatever has to be carried out in accordance with the Supreme Court's directions, my lords. Now, this was not complied, sir. So we filed a contempt petition, which was 3135 of 24.
Right.
On 29/8/24, notices were issued to Tehsildar. Now, Tehsildar kept on taking time. Finally, my lord, for his personal presence when it was called, he passes an order on 21/11/24 in accordance with the Supreme Court's direction, making all entries in the Khasra and the revenue records in favor of respondent number 1. The mutation gets completed, my lord. And thereafter, on 12/12/24, he appears before the contempt court and says, sir, हमने पूरा 21/11 को पास कर दिया है, अब इसको ड्रॉप कर दीजिए. Accordingly, 12/12/24 ड्रॉप हो गया. Thereafter, my lord, appeal is filed by Menaka Gandhi and the present appellants before the SDO, saying that stay the order which has been passed by the Tehsildar. Now, the SDO aware, why? Because the order is very clear. SDO is aware of the order passed by Honorable the High Court, both initial order of 3/3, subsequent of the review petition, subsequent of the contempt petition, aware of everything. Yet, he sits over the order of the High Court and grants the stay of the order passed by the Tehsildar, that is 21/11/2024. Against that, my lord, we file again a CCP, which is 387 of 25, wherein notices have been issued. It is pending, my lords. Now, what is important is they say they are not aware of it. From the documents which are on record, it's clear that they are aware of the proceedings which were going on. They are not oblivious of it. Number 2, why, my lord, I brought to my lord's knowledge the judgment of the Supreme Court. Now, what happens, my lord? Mother of the appellant's hearing is Amteshwar Anand. Now, there were 3 compromise agreements which were entered into after the death of Sir Dattar Singh, the father, my lord.
That is on merit.
No, what I'm trying to say, no.
Yeah.
Once the mother, even otherwise, once the mother relinquishes her right, it is there in the judgment. She relinquishes. They independently, they have no right to the property.
Right.
It was Amteshwar Anand who came to the court along with Kripal Kaur, that is the mother of Gunita. They went to the Supreme Court challenging the partition family settlement. High Court said, first High Court of Delhi said, no, everything is in order. Against that, they go before the division bench of the High Court. The division bench said, no, perfectly, the 3 compromise family settlement is perfectly legal, valid and justified. That being the position, travel to the Supreme Court. Supreme Court passes a very detailed order, and there the daughters file an IA saying that कि हमको पैसा नहीं मिला. So the court says 2 things very important. Therefore, I was wanting to draw. If there was a relinquishment by Amteshwar Anand, you have no right. If any money is due to you, proceed in accordance with law. But this agreement, compromise agreements on which the decree has been passed, cannot be rescinded by any court now. This was a judgment of the Supreme Court.
Right. Yes.
And then it just one second.
Yeah.
For the condemnation, my lords, if I can just draw 2 judgments, my lords, add along with my Supreme Court के judgment के साथ में मैंने 2 judgments पेश किए सर. Now, इनका यही केवल कहना है कि साहब हमारे को हम पार्टी नहीं थे तो हमें नॉलेज नहीं था. जहां आप पार्टी हम दिखा रहे हैं आपको कि आप पार्टी थे 20 में आपको था तो आप कैसे 25 में चले आए. तो 20 से लेके 24 का आपका एक्सप्लेनेशन तो कोजन नहीं समझता. इट्स नॉट सैटिस्फैक्टरी. when the delay condonation application does not give an effective explanation, proper and reasonable, being inordinate delay, Supreme Court dealt with these issues. These are two judgments, my lord, which are we have filed, my lord. One is 24 Supreme Court, my lord, 2024 Volume 4 SCR, KB Lal versus Gyanendra Pratap and others. The relevant paras are 8, 9, and 10.
KB, yeah, KB.
8, 9, and 10
Yes.
regarding the condonation. In para 10, the entire thing was dead. So there has to be a reasonable explanation. Only thing is that not a party. And therefore unaware. We are there with the court on an order where they are a party there.
Which para you are like?
तहसीलदार
KB Lal.
जी और दूसरा जो है सर 2022 सुप्रीम
KB Lal, which para you say?
Which para?
सॉरी the first case का
Lal one. First.
8, 9.
para will be 8, 9 and 10. 8, 9 and 10. It was how the facts of the 8, 9 dealt with and 10 पूरा case laws को dealt करते हुए सुप्रीम कोर्ट ने कहा it cannot be possible at all. And वहाँ तो डिले कम था, यहाँ तो डिले बहुत है. Each day needs an explanation. This is what Supreme Court says, but not being very hypertech about it. Let there be some very reasonable explanation. That is not there. The second case for my lord's appreciation would be 22 Supreme Court, my lords. That is Maji Sanama.
Yes.
That is para 1, 6, 7, 8 and 9. यहाँ पे डिले था 1011 days का. यहाँ तो कम है, यहाँ तो और भी ज्यादा है. And para 6 से है, 7 है, और डिले के कंपोजिट में सुप्रीम कोर्ट को दिखाते हुए finally it says that there has to be a reasonable explanation. The third component in this case would come now, my lord, is
That's all.
third component, sir, is जो इन्होंने पावर ऑफ अटॉर्नी पेश किया है. उसमें नोटिफिकेशन हमको मिला है कि वो सब सेम है सर. There hasn't been any. आप वो फाइल कर दिया मैंने जजमेंट के बाद ही मैंने इसमें नोटिफिकेशन भी लगा दिया है सर दिल्ली का. Everything is in intact, sir. Then the notification is of November 2007, sir. There is something else.
Yes, please.
And one more thing, sir.
Power of attorney,
Power of attorney का file.
that was executed in Delhi.
दिल्ली का
Yes.
नोटिफिकेशन चेंजेस नहीं हुआ है सर उसमें. तो उसमें क्या है 500 रुपए का व्हिच इज इन द स्टैम्प एक्ट द शेड्यूल
500 रुपए जो कह रहे हैं वो एमपी का है. 500 रुपए up to
का सेम है. दिस इज व्हाट इट वाज सेड. There isn't a change. I stand corrected then, my lords.
Okay.
I bow before my lords. I bow
Anyway,
before my lords.
yes.
Bow before my lords. Now, one more thing important. Just a second.
Yes.
One more.
Yes.
इसको थोड़ा सा पावर ऑफ अटॉर्नी को देख ले प्लीज. R1 वॉल्यूम R13 को पेज 15 में ही. The first few lines and the last.
Yes.
Am I there with my lords? Srimati so and so, Putri so and so, house number so and so, even Srimati so and so. So the present appellants were Gunita Kaur, Putri Srimati Kripal Kaur Dwara. Now because important. Mukhtar Aam कौन है? Varun Gandhi is the power of attorney holder. Varun Gandhi पुत्र so and so निवासी अशोका. So power of attorney इन्होंने किसको दिया सर? इन्होंने दिया वरुण गांधी को. Now let us come sir. नीचे आ जाए थोड़े से 1 2 3 4 5 6 7 8 लाइन फ्रॉम द बॉटम इसी पेज में जहां पे ये पूरा खसला के बारे में लिखने के बाद में भूमि के संबंध में am I there with my lords?
Yes.
भूमि के संबंध में सीमांकन कार्य, अतिक्रमण कार्य, राजस्व निरीक्षक के कार्यालय के कार्य, पटवारी कार्यालय के कार्य, तहसील न्यायालयों के कार्य, अनुविभागीय अधिकारी महोदय के कार्यालय, न्यायालय व माननीय कलेक्टर महोदय के कार्यालय व न्यायालय व उक्त भूमि से संबंधित राजस्व कार्यवाही हेतु हमारे द्वारा Shri Govind Singh Yadav, already the general attorney is with Mr. Varun Gandhi. Shri इसके add on करके ही कर रहे, is it permissible in law? Shri Govind Singh Yadav, पुत्र so and so, Vinod Yadav, पुत्र so and so एवं सुरेंद्र सिंह यादव पुत्र so and so को अधिकृत करते हैं, वे उक्त संपूर्ण कार्रवाई करने हेतु हमारी ओर से हस्ताक्षर करें। कार्रवाई करने हेतु उपस्थित होकर वह हस्ताक्षर कार्रवाई करने हेतु अधिकृत होंगे। उसके उनके द्वारा किया गया कार्य ऐसा माना जाएगा कि वो हमारे स्वयं के द्वारा किया गया।
राइट वो सब उनका
आगे देखेंगे तो लगता है कि शायद ये इन्होंने बेचने का है। That's what I mean. हम
नहीं वो बेचने का भी साथ में है, कार्यालय में बेचने, कार्यालय सब कुछ करने का है।
नहीं ये इन्होंने बेच दिया इनको, ये आगे इसमें देख, इसलिए मैं बताना चाहती हूँ। हम उपरोक्त वनित भूमि के संबंध में ये व्यक्त करते हैं कि उक्त भूमि का नामांतरण हमारे द्वारा विधि अनुरूप किया जाएगा, हमारे द्वारा किया जाएगा। इसके श्री गोविंद सिंह यादव, विनोद यादव, सुरेंद्र सिंह यादव को यह अधिकार होगा कि वह उक्त भूमि के संबंध में जाहिर सूचना आदि का प्रकाशन करने हेतु स्वतंत्र होंगे। हमारे द्वारा उक्त भूमि के संबंध में उनसे आंशिक अग्रिम राशि भी प्राप्त की जा चुकी है। वर्चुअली अ ट्रांसैक्शन हैज टेकन प्लेस, वो है ये डॉक्यूमेंट। वर्चुअली टू सी दैट which needs a registration, sir. और ये नोटराइज हुआ है सिर्फ,
ये वही तो ये दूसरा।
और इसमें वरुण गांधी के दस्तखत भी नहीं है।
And they are lying upon that page 74.
My lord, that is different.
Page 74.
We have filed page 74. We have
See page 74. They are lying upon.
इन्होंने एसडीएम क्या पेश की ना? Page 74 along with the this writ appeal. This attorney they have placed before SDM court.
Same thing.
Which you have read.
Is it the same?
No, it is not same. ये पेश की है, वो attorney की है, वो
It's a different.
ये यहाँ पर पेश किया है, यहाँ पर ये पेश किया हुआ एसडीएम पे पेश किया है।
Right.
ऐसा हमें
तो ये है इनका, yes, yes, that's all. We'll consider. Yes, please.
My lord, since the power of attorney is different, my lord, so the argument what is
Right,
done,
no
that
difference.
is not.
This is what you are
Now,
saying.
so far as the delay is concerned, my lord, lordship, we have filed this appeal against the order dated 23 April, that is P12,
Order
passed
date-
on the review petition 242 of 24, arising out of the order dated 3/3. My lord, since if
Just
in the order, my lord, which has been read over, that is the order of the Tehsildar dated 13, my lord. After this 13/7/2020, my lord, they were also having knowledge that we have the party. So it was supposed for them to make me a party, my lord. Deliberately by suppressing the fact, my lord, they did not impede as a party. Now, even after that, my lord, after the order passed in RP, my lord, the order of the Tehsildar may also kindly be seen A11 page 59, my lord. And that is the application filed by them which was allowed, against which we have preferred the appeal before the SGO. In that also, my lord, it is mentioned Sarv Sadharan. In this space before the Tehsildar also, we have not been impeded as a party, my lord. So the moment we got the knowledge, my lord, we have come approach before this honorable court. Moreover, my lord, there are the judgments, I will give the my lord. My lord, this is the judgment where the judgment and decree or order obtained from the court by concealing the important fact, that is amount to a fraud with the court, and it can be assailed at any stage. My lord, suppression of, I was the family member, my lord, my interest was there, and we have not been impeded as a party. So there is a judgment that necessary party of the respondent was not joined as a party in the suit, and judgment and decree was obtained. The act of the petition, another plaintiff respondent number 2 amount to playing fraud with the court, and in this case, relying on the Supreme Court, it was held that it can be assailed at any stage because the non-impediment of party is necessary, my lord. And so far as the what my learned senior has said, my lord, there is one Supreme Court judgment that day-to-delay explanation is now good law, my lord. This is reported in this is a judgment of Supreme Court in 2018, my lord. That each day delay is not to be explained, my lord.
Yes.
And my lord, apart from this, my lord, No, they are, my lord, even what has happened after this, my lord, when this order was passed, which is at A7, my lord, they prefer that contempt petition, my lord, that was discharged with the contempt was discharged. And so far as Gunika Kaur is concerned, we have no concern with the Gunika Kaur. She is the step sister. We are the two real sisters who are the necessary party, my lord. They were to be implemented. Gunika Kaur might have filed some separate writ appeal and whatever, and what the it has been read over that power of attorney that is not on the record. We have filed a separate power of attorney on the basis of which we have filed this appeal. So, my lord, we have shown the sufficient cause, and there is suppression of fact by them, my lord. It was for them to implead as party to disclose before the Tehsildar that the other interested parties are also there, my lord.
Right.
And apart from that, my lord, they have suppressed in everywhere they have suppressed that order whereby the execution has been withdrawn. That is A4, my lord. Once execution has been withdrawn, their money have been refunded, my lord. There was an order. Then nothing remains like that, my lord. That and they have suppressed all these things. Subsequent order 12 par 14 ka. All material have been placed before the Tehsildar and everywhere regarding the order dated of 2007, 7 अक्टूबर 2005 के order को सब जगह दिखाया है.
Just note down the prayer.
एक बात मुझे कहना है सर.
जी मैडम.
This is not a case, sir, where you were not a party earlier or something of that kind, my lords. So therefore, please permit me to take, my lords, the judgment of the Supreme Court, just one para at page 7, where clause D Supreme Court जो reproduce किया है agreement का, वो D कहता है, Srimati Amteshwar Anand, that is mother of both of them, hereby acknowledges that she has already received the consideration from Sri B.M. Singh in respect of her rights, which would have accrued on partition in respect of the entire properties situated at village Behta, Borbao and Lokheri, Tehsil and district Bhopal, and also village People Kera, district Raisan. So this is what they have received, everything. Mother, this is what Supreme Court, my lord, says it very, very clearly. And then further, that Srimati at page, internal page 8 of the judgment, Srimati Amteshwara Anand has relinquished, released, given up, assigned all her rights, title and interest in all the movable and immovable properties, which are the subject matter of the present suit, or such properties, which are the subject matter of the suit number 63 of 75, subject to clause E aforesaid. All these properties to the extent of share of Srimati Amteshwara Anand shall deem to vest be the exclusive properties of the defendant, Shri B.M. Singh, subject to the payments being made as specified aforesaid. Shri B.M. Singh shall be the owner of all interests, rights, benefits that have accrued or may accrue in favor of Amteshwar Anand and shall be deemed to have been assigned in his favor, and he shall be treated as the exclusive owner to the extent of the share owned by Srimati Amteshwar Anand, including the shares devolving on her from late Sir Dattar Singh, Lady Satwan, so. This is how the Supreme Court says, my lord, and further, they kept on saying that the agreement will be deemed to be cancelled. Page 11 of the judgment Supreme Court says.
Madam, this is all you are only.
मैं इसी कह रही हूँ सर कि ये judgment हो चुका है Supreme Court द्वारा.
Just wait. Take note. Just note down the prayer. It's good. The present application has been strongly opposed by the Counsel for Non-Applicant Respondents by submitting that the writ appeal has been filed with delay of 1631 days from admitted knowledge of the order dated 13 July 2020 passed by Tehsildar, Tehsil Huzur, as you said, you are Bhopal, upholding the objections of the appellants. Stop. Otherwise, there is a delay of 175 days from the passing of order dated 3/3/2020. Stop. Further stated that there is a delay of 917 days from 27th June 2022 when the appellants challenged the order in contempt dated 11/5/2022 passed in violation of order dated 3/3/2020, passed in WP number 5227/2020 in the Supreme Court. Stop. Further submitted that there is a delay of 249 days in filing appeal against the order dated 23rd April 2024, passed in review of order dated 3/3/2020. Stop. Para. Learned senior counsel appearing on behalf of non-applicant respondents submit that appellants as well as the respondent number 5 who vigorously jointly contested the mutation proceedings before the Tehsildar Bhopal since 2019 and are still contesting proceedings in the revenue courts were in the knowledge of the impugned order dated 3rd March 2020 as the copy of the order was handed over to their counsel / Mr. Sandeep Khare before it was given to the Tehsildar for implementation of the order. Stop. Para. Learned civil counsel further submitted that the appellants again had knowledge of order when the Tehsildar passed order dated 13 July 2020, wherein on page of the order he has mentioned that though the High Court directed wide order dated 3/3/2020 passed in WP number 5227 of 2020, that mutation order be passed in 4 weeks, the delay in implementing the order was due to the offices being shut down because of COVID. Stop. The Tehsildar rejected the decree passed by the High Court of Delhi. It's a High Court Delhi.
Yes, madam.
This court, no, Delhi High Court,
Delhi High
passed by Delhi High Court, which was upheld by the Honorable Supreme Court and rejected the mutation application, by accepting the appellant's objection. Stop. She also submitted that the learned single judge of this court summoned the Tehsildar in contempt petition being contempt number 428 of 2022 as the Tehsildar had not acted in accordance with law. Stop. Not satisfied with the reply of Tehsildar, the contempt court summoned the Tehsildar on 11 May 2022, the appellant as well as the respondent number 5, started the legal process to damage control the issue as the Tehsildar only acted under their instructions. Stop. She submitted that as per their strategy during vacations on 15 June 2022, Kumari Gunita approached this court by filing a writ appeal against order dated 11 May 2022 in contempt case number, this is contempt case 428
428,
2021, which was passed in violation of order dated 3/3/2020 in WP number 5227/2020, and on the other hand, the appellants filed a SLP diary number 18874 of 2022, against the order dated 11th May 2022 in contempt case number mentioned above, for violating the order dated 3/3/2020. Stop. The Honorable Supreme Court on oral mention wide its order dated 27th June 2022 dispose of the matter granting permission to the appellant, which is granting the appellant. That's all. Stop. Para. She submits that again the appellant were in a knowledge of order dated 3/3/2020 when they approached the Honorable Supreme Court in the month of June 2020. Thus, there is a delay of 917 days from the date of filing the writ appeal. Stop. Para. See, submit that the delay has to be explained properly, and it held in case of K.B. Lal versus Gyanendra Pratap and others. This is 2024 AIR SC Civil 1524 and para 10 reproduce agenda. Stop. Para. Whereas the grounds of the applicant slash appellant while seeking condonation of delay submitted that the present appeal could not be filed within prescribed period of time as present appellants were not the party in the review petition 242 of 2024, in the first week of November when the appellant's attorney went to the revenue court for their another work. However, he came to know about the order dated 23rd April 2024 passed by this court in RP number 242 of 2024 as well as about the order dated 21st November 2024 passed by the Tahsildar Nazul Bairagad Bhopal in case number 1486/A6/2024-25. Stop. Thereafter, on 25th 11/2024, the applicant slash appellants prefer appeal under section 44 within bracket 1 of MPLR code 1959 before the SDO against the order dated 21st 11/2024, which is still pending. Stop. Para. Counsel appearing on behalf of the appellant applicant slash appellant submit, since the respondents did not pleaded the appellants in the RP 242 of 2024 and therefore no occasion arises to the appellant to challenge the order dated 3/3/2020 and 23rd April 24 passed by this court. Stop. As soon as the applicants got knowledge about the order dated passed in RP mentioned above from the revenue court, they filed the present writ appeal. Stop. Para. In KB Lal Supra, the Honorable Supreme Court observed that to condone delay, the exercise must be judiciously, and it is not to be exercised in case where there is a gross negligence and want of due diligence on part of the litigants. Stop. It is also discussion is also not supposed to be exercised in the absence of any reasonable, satisfactory, or appropriate explanation for the delay. Stop. In the present case, admittedly, just admittedly, the respondents did not plead the appellants in RP 242 of 2024 and 24. Therefore, the appellants could not challenge the order dated 3/3/2020 and 23rd April 2024 passed by this court. Stop. The applicants got knowledge about the order dated 23rd April 2024 passed in RP 242 of 2024 from the Revenue Code. Thereafter, they filed the present appeal. Stop. Well, the respondents failed to explain as to why the appellants were not made party in RP 242 of 2024. Stop. In view of above, we hereby allow the while condoning the delay in filing the appeal, allow the present application and accordingly disposal of that. Stop. Correct. In appeal, notice issued. So and so accepts notice on behalf of the respondent, and the list the present appeal for final hearing on week commencing 21st April 2025 for final hearing at the motion stage. Stop. Parties are directed to file written submissions with case law relied upon within make it within 2 weeks.
Thank you.
Serial number 32.
Keep